Okay, I'm on page 446 for Chapter 15, courts. Going back to the different levels, it's like a hierarchy of courts. You have the district court is the trial court, and then if you appeal from district court, it goes to the Court of Appeals, which you should know as circuit court. And then finally, if you might attempt to appeal to the Supreme Court, although that your chances of actually getting there are very, very rare. The entry point for most litigation in the federal court is one of the district courts, of which there are 91, with at least one in each state. I believe there are two in Michigan, Grand Rapids, and Detroit, in addition to one in Washington, D.C., and one in Puerto Rico. There are also three somewhat different territorial courts for Guam, Virgin Islands, and Northern Mariana Islands. The district courts are courts of original jurisdiction. They hear no appeals. They are the only federal courts that hold trials and impanel juries. The 678 district court judges usually preside over cases alone, so there's only one judge. But certain rare cases require 3 judges constitute the court. Each district court has between 2 and 28 judges, depending on the amount of judicial work within its territory. So in Grand Rapids, there are multiple judges hearing multiple cases at the same time, but there's only one judge sitting there on any given case. And again, these are original jurisdiction. This will have juries, witnesses, evidence. So we have federal crime. So why do you go there? Why would you end up in Grand Rapids District Court? Federal crimes. Keep in mind that about 98% of all the criminal cases are heard in state and local court systems, not in the federal courts. Moreover, only a small percentage of the persons convicted of federal crimes in the federal district courts actually have a trial. Most enter guilty pleas as part of a bargain to receive lighter punishment. Plea bargains, it is a test question, I believe. Over 90% of criminal cases, state and federal, never even make it to trial. Civil suits under federal law. This is where you'll see many cases. When you hear about cases, this is what you're going to hear about. As with criminal cases, state and local courts handle most civil suits. Also, as with criminal cases, only a small percentage of those civil cases that commence in the federal courts are decided by trial. About 1% of the more than 280,000 civil cases resolved each year. In the vast majority of cases, litigants settle out of court. There's risk to going to trial. And if you're sued, if someone's sued or a business is sued, it's often considered, because they have insurance, that it is safer to go with the known of settling out of court and paying out than through the money and the time and the uncertainty of going to trial in front of a jury. So just because someone settles out of court, don't automatically assume they're always 100% wrong. There are companies and groups that will settle just because it's cheaper and easier. Civil suits between citizens of different states or between a citizen and a foreign national where the amount in question exceeds $75,000. I don't ask anything about that. I need you to know federal crimes, civil suits under federal law. Also, you have to know bankruptcy, because bankruptcy is Article 1, Section 8. It is an enumerated power. Review of the actions of some federal administrative agencies. Admiralty and maritime law cases, again, Article 1, Section 8, military. Supervision of the naturalization of aliens. Again, naturalization, Article 1, Section 8, it's an enumerated power. Patent copyright lawsuits are going to fall under civil suits here because Article 1, Section 8. So anything under Article 1, Section 8, post office, etc., would fall under federal court. District judges rely on elaborate supporting cast, including clerks, bailiffs, law clerks, stenographers, court reporters, and probation officers. U.S. Marshals are assigned to each district to protect the judicial process and to serve the writs that the judges issue. Federal magistrates appointed to 8-year terms issue warrants for arrest, determine whether to hold arrested persons for action by a grand jury, and set bail. They also hear motions subject to review by their district judge and with the consent of both parties in civil cases and the defendants in petty criminal cases, preside over some trials. We also have magistrates at the state level who do the same thing. You might choose to go in front of a magistrate instead of in front of a judge. To note a grand jury is not the same as a petite jury. When we talk about juries, we're usually talking about petite juries. Grand juries are the juries of citizens who meet before anything happens to determine if a case has enough evidence to go to trial. The last jury is the one we think of, the one that determines guilt, not guilty, or who's liable, who's at fault in a lawsuit. Michigan rarely has grand juries, so we don't hear much about them. Some states have them more than us, but the federal government has them as well. We typically have a prosecutor decide if there's enough evidence to move forward and prosecute a case. They also hear motions subject to, I said that. Let's see. Moving on to the next part. Another important player at the district court level is the U.S. attorney. Each of the 91 regular districts has a U.S. attorney who is nominated by the president and confirmed by the Senate and who serves at the discretion of the president. No lifetime appointments. They're attorneys, not judges. These attorneys and their staffs prosecute violations of federal law and represent the U.S. government in civil cases. Most of the cases handled in the district courts are routine, and few result in policy innovations. Usually, district court judges do not even publish their decisions. Although most federal litigation ends at this level, a large percentage of the cases that district court judges actually decide, as opposed to those settled out of court or by guilty pleas, go forward on appeal. A distinguishing feature of the American legal system is the relative ease of appeals. U.S. law gives everyone a right to an appeal to a higher court. The loser in a case only has to request an appeal to be granted one. Of course, the loser might pay a substantial legal fee to exercise this right. So you'll hear someone come out and they'll say they're found guilty and they'll say, well, we're going to appeal. Well, yeah, they're going to appeal. They can appeal, not a big deal. That's good, but they're probably going to lose it. You actually have to to win an appeal is versus just filing the paperwork, two different things. I want to note here, our Grand Rapids Federal District Court tends to deal with immigration issues and maybe large drug possession, which looks like larger drug dealings. You go to a San Francisco District Court and they're going to be dealing with more patent and copyright law because of Silicon Valley. So different Wyoming, I would say District Court out west might be dealing with federal land use, cases on that. So different parts of the country have different types of laws that they're dealing with concerning, the businesses, the sector of economy that is around there. Okay, so let's say you appeal. Probably not going to get anywhere, but you appealed it. Congress has empowered the U.S. Courts of Appeals to review all final decisions of district courts, except in rare instances which the law provides for direct review by the Supreme Court. Courts of appeals also have authority to review and enforce the orders of many independent regulatory commissions, such as the Securities and Exchange Commission and the National Labor Relations Board. Most of the more than 53,000 cases filed in the Court of Appeals each year come from the district courts. The U.S. is divided into 12 judicial circuits, including one for the District of Columbia. Ours, you'll see here, we are the 6th Circuit. Each circuit, except that for D.C., serves at least 2 states and has between 6 and 28 permanent circuit judgeships, 179 in all, depending on the amount of judicial work in the circuit. Each Court of Appeals normally hears cases in rotating panels consisting of 3 judges, but may sit en banc, I don't know if I'm saying all that right, with all judges present in particularly important cases. Then it would be 6 judges. Decisions in either arrangement are made by majority vote of the participating judges. There's also a special appeals court called the U.S. Court of Appeals for the Federal Circuit. Congress established this court composed of 12 judges and 82 to hear appeals in specialized cases such as patents, claims against the U.S., and international trade. The courts of appeals focus on correcting errors of procedure and law that occurred in the original proceedings of legal cases, such as when a district court judge gave improper instructions to a jury or misinterpreted the rights provided under a law. These courts are appellate courts and therefore hold no trials, hear no testimony. Their decisions set precedent for all the courts and agencies within their jurisdiction. And we'll be talking about this one. Because of circuit splits and the Supreme Court, keep in mind then this part where it says misinterpret the rights provided under a law. So if you're suing for something and you believe the law should say you can do that or can't do that, and we'll get into so many examples like this with civil liberties next chapter, that how it's decided if that's a misinterpretation of law is the giant question that gets ultimately often to the Supreme Court. Is it a misinterpretation of law? Is it a misinterpretation of the Constitution? And that's where we're headed for this unit, this chapter, this next chapter. Although keep in mind that most cases, the bulk of people going in and out of those buildings are just procedural, just cases that probably get plea bargained and people move on, or appeals that don't get granted. I also want to note here, the disparity in the size of the Ninth Circuit. The Ninth Circuit, given the size of California and the growing in Oregon and Washington, is a very large circuit, and it's based on arguably some antiquated population numbers, and we're just like many things in the U.S., there's a lack of will to, because of partisan differences, to want to readjust and create new circuits, because that has its own political drama as well. When you create another circuit or add more judges, that gives the president power because the president picks those judges, and the other party might resist that in order to make a law to change this and update the population needs of these circuits. Yet again, politics gets played in there because Congress does that. It's not in the Constitution. Okay, so now we're going to go over the Supreme Court, which is the bulk of everything here. With 12 minutes here, I'm going to go with the next section here about the Supreme Court. Sitting at the pinnacle of the American judicial system is the U.S. Supreme Court. The court does much more for the American political system than decide individual cases. Among its most important functions are resolving conflicts among the states and maintaining national supremacy in the law. The Supreme Court, or SCOTUS, S-C-O-T-U-S, also plays an important role in ensuring uniformity in the interpretation of national laws. For example, in 1984, Congress created a federal sentencing commission to write guidelines aimed at reducing the wide disparities in punishment for similar crimes tried in federal courts. By 1989, more than 150 federal district judges had declared the law unconstitutional, and another 115 had ruled it valid. So there was a split in how the district judges were handling this law. Only the Supreme Court could resolve this inconsistency in the administration of justice, which it did when it upheld the law. What it's upheld means it says the law is constitutional and can be used. There are 9 justices on the Supreme Court. All of this is on the test, by the way, coming up here. 8 associates and 1 chief justice. Only members of the Supreme Court are called justices. All others are called judges. The Constitution does not require this number, however, and there have been as few as 6 justices and as many as 10. Congress altered the size of the Supreme Court many times between 1801 and 1869. In 1866, it reduced the size of the court from 10 to 7 so that President Andrew Johnson could not nominate new justices to fill 2 vacancies. When Grant took office, Congress increased the number of justices to 9 because it was confident that he would nominate members to its liking. Since then, the number of justices has remained stable. But again, 9 justices is not required. All 9 justices sit together to hear cases and make decisions, but they must first decide which cases to hear. A familiar battle cry for losers in litigation in lower courts is familiar battle cry from people who don't know anything, and you don't sound smart when you say it, by the way. I'll appeal this all the way to the Supreme Court. In reality, this is unlikely to happen. Unlike other federal courts, the Supreme Court decides which cases it will hear. Remember, when you appeal, which just means you file some paperwork, they have to read it. The appellate courts have to read it, and chances are they're going to deny it. The Supreme Court makes its choice on whether or not it's even going to hear your appeal. As you can see in Figure 15.3, which illustrates how cases reach the Supreme Court, the court does have an original jurisdiction, yet very few cases arise under it. Original means the first to hear a case. Their appellate jurisdiction. The government does not usually wish to prosecute diplomats. It just sends them home. And there are not many legal disputes involving states, as opposed to, say, a prosecutor representing a state in criminal trial. Almost all the business of the court comes from the appellate process. Litigants may appeal cases from both federal and state courts. However, as documented in Table 51, the vast majority of appeals heard by the Supreme Court are from federal courts, federal appellate court. Appeals from state courts must involve a substantial federal question in deference to the states, as I said before. The Supreme Court hears cases from state courts only if they involve federal law, and then only after the petitioner has exhausted all the potential remedies in the state court. Again, rarely happens. Losers in a case in the state court system can appeal only to the Supreme Court and not to any other federal court. The court will not try to settle matters of state law or determine guilt or innocence in state criminal proceedings. To obtain a hearing in the Supreme Court, a defendant convicted in a state court might demonstrate, for example, that the trial was not fair as required by the Bill of Rights. See, now it's a federal issue. It's a U.S. Constitution issue, which was extended to cover state court proceedings by the Due Process Clause of the 14th Amendment. 14th Amendment, often considered the most important amendment in the U.S. Constitution. We'll go over that in the next chapter. Okay, I'm going to leave it there and start up on the next one in the next section.